My name is Antonia Merzon. I'm a senior attorney at the Prosecutors Center for Excellence, and I was a prosecutor for many years with Chris in the Manhattan DA's office, though I have now been living for many years in beautiful Boulder, Colorado, from which I'm joining you today. So yes, this sudden emergence of generative AI as a feature that lawyers generally can use and prosecutors specifically, which we'll talk about today, and what that means in terms of the ethical obligations that attorneys have to be considering when they're using these tools. Just a little reminder that all attorneys around the country are governed by a code of professional responsibility. Each state promulgates one. Many are created by the state bar associations. In some states, however, they come out of either the Supreme Court or some judiciary committee of some kind that is the keeper of these rules. In most states, some or all of their rules of professional responsibility are taken from the American Bar Association's model rules of professional responsibility. Um, the ABA is a nonprofit organization that's been doing this for decades. And along with these rules, they issue formal ethics opinions on a variety of legal issues that generally come out of their subject committees, including their Committee on Technology. And they also, just as an FYI, are an excellent source of research and articles about AI and many, many other technology issues. So not surprisingly, about 6 weeks ago, the American Bar Association issued a formal opinion about the use of generative AI tools. And again, these are the tools that have the capacity to actually create content, items, images, things that a lawyer might use for various purposes. And it's a long opinion, and it provides guidance about, as they say, navigating this landscape. And it provides a lot of sort of hands-on ideas about how to meet your ethical duties while trying to use these tools. And it notes 6 particular rules of professional responsibility that come up in the use of a generative AI tool: competence, confidentiality, communication, meritorious claims, and candor to the tribunal. That just means not doing anything frivolous or misleading in front of a court. The supervisory responsibilities of attorneys when it comes to these tools, and fees. Just a quick look at what they had to say on those. I've highlighted in purple what are sort of key takeaways. In reality, everything about the decision is a key takeaway, and I highly recommend you read through the whole thing. But in terms of competence, as with any technology, an attorney has to have some reasonable understanding of the tool they are thinking about using. And particularly with AI tools, that involves an assessment of what the tool can do and what it can't do, and what the risks and benefits of using the tool are. And just in a very practical way, that means reading, research, attending webinars like this one, consulting with experts. It's not sort of a, oh, I've heard about this. It means actually spending the time to develop some reasonable understanding of what you're thinking about using. And the reason for that is because, as we've been hearing, these tools come with risks, that the output you might obtain from them is incomplete, biased, wrong, hallucinated, outdated, all those things. And so reliance on that output without some kind of independent verification of what you're seeing and hearing from the tool could potentially constitute a violation of your duty of competence. Bottom line, as they say, you are fully responsible for your work as an attorney, whether using the assistance of a paralegal, program, software, a tool. You are responsible for their work and your work at the end of the day. Confidentiality, of course, is a huge issue with these tools. And I would say, especially for prosecutors, given the sensitivity of the data that they handle. And the ABA says that the lawyers have an ironclad responsibility to evaluate the risk that any information they input into one of these tools could potentially be disclosed to others. That these are self-learning tools that by their nature take in data use that data to feed their algorithms, and as a result, may output information to other people using that tool based on the data they've gathered. So if you're putting case information, the results of search warrants, um, criminal justice information, as Rick Zach described, into one of these tools, you have to be completely certain that the output of someone else's query into the tool might not get some of that data in the results. And to do
Right.
that, that requires, reading the terms of use, as Sarah was just describing. Who owns the data? What's going to happen to it? What's the privacy policy? What are the contractual terms? And consulting with anyone you need to consult to answer that question about confidentiality. And then in terms of the other responsibilities they describe, I mean, communication, this may have a little more relevance in the private sector where attorneys are communicating directly with, paying clients. But the main point here is that if GAI tools are going to be, having input into a significant legal decision that you're making, you would need to disclose that to your client. And in the prosecution sector, think about who might need that type of disclosure, even if it's supervisors, even if it's law enforcement partners. It comes up in this context as well. In terms of candor to the court, the basic idea is you don't want to mislead the court. You don't want to make false statements. You don't want to make a motion or do something that's frivolous. And so if you're relying on the output of an AI tool, you have to carefully review whatever it's telling you to make sure that what you are then relaying to the court is accurate. And, Sarah was talking about how they, decided to disclose the use of AI in various contexts. There are some courts now requiring parties to disclose if they used AI in the production of a motion or anything of that nature. Key to prosecutors, key to all lawyers, is the supervisory responsibilities issue. And the ABA says if you are a supervising attorney in any legal organization, you have to create policies, as we've heard, about how that organization is going to use these type of tools. And then attorneys have to make efforts to make sure the lawyers and non-lawyers in the organization are complying with those policies and the general ethical obligations of attorneys and prosecutors, and that any third-party providers or partners that you're working with that are using AI tools are doing so in a manner that conforms with these ethical obligations. Now, as prosecutors, we don't really deal with fees, but their point in the opinion is that if AI is significantly reducing the time an attorney is spending to conduct certain projects on behalf of the client, that should be reflected in the fees. They should be charging less. And while that's not really a concern of prosecutors, what it also is really saying is that jobs are going to change. If AI is now able to speed up the time it takes to do something, and you used to have an employee spending all day on that job, you're going to have to be changing your practices to reflect, how the AI has influenced that, and that may come out in budget items, it may come out in the amount of employees you need and justify to your budgetary funders. There's 6 states besides the American Bar Association and its opinion, there's 6 states that currently have AI ethics opinions, and they're all listed here. And there are also, just to jump ahead, 3 states that haven't issued an opinion, but they've issued what they call guidance. And one thing you might notice about all of these is these were all issued before the ABA issued its opinion at the end of July. And I think these informed a lot of the ABA's opinion. These are worth reading, obviously, particularly if you're in that state, but even if you're not. For example, the New York guidance is an 85-page report about what AI is, how it works for attorneys, what all the risks and pitfalls and everything are. The Washington, D.C. opinion does a very good job of outlining potential risks for prosecutors and attorneys. The Kentucky opinion also goes into that in some depth, but they all highlight different issues. Certain states have more specific rules in their code of professional responsibility that they highlight for those states. I think now that the ABA has issued an opinion, many states are going to adopt that opinion as one representing their state as well. So this list is likely to grow in the coming months.
1 minute.
That's a little overview of what's going on in the world of ethics and generative AI. Here's my email address, and feel free to contact me at any time if you have any questions about that.